Hello and welcome to part 3 of our trademarks introduction. My name is Edward Carstairs and I'm a partner at Gill Jennings Every, which is a specialist IP law firm based in London and Munich. I'm a qualified UK and European trademark attorney, so I primarily help our clients protect their brands. I work across businesses from a variety of different sectors, including food and drink, fashion and sportswear, consumer electronics, media and entertainment, and financial services. I also work with businesses at various stages from startups through to large multinationals. We also have specialist patent attorneys in our chemical and life sciences and IT and engineering teams, providing both patent and design advice. In part 3 of this talk, we'll be looking at the issues surrounding enforcement when you have trademark registrations in place, and then we'll finish off by looking at some common misconceptions associated with trademarks. So, turning first to trademark enforcement. Once your trademark is registered, you need to remain vigilant as to what is happening in your market. When you have a registered trademark, it can form the basis of a challenge to anyone that gets too close. But remember that trademark rights are territorial. So a trademark registration in the UK does not necessarily mean you have a basis to challenge someone in another territory. Increasingly, what we're seeing is individuals and companies in the Far East combing trademark registers in the UK and Europe, and who will register other companies' brands for themselves. So as mentioned before, this is why it's important to consider your wider business plan early in the trademark process. In China, we often see a number of trademark squatter issues. So we have a few examples here with the Sunbox coffee, we have the McDonald's Golden Arches upside down, and we have the Boreo cookies. Trademark squatting can lead to a range of serious potential problems for your business, all of which are expensive and difficult or even impossible to resolve. They can put your whole business at risk. So for example, you could be prevented from using your own brand or exporting products into a new territory. So for example, in China, even if your use predates a squatter mark, you can only take action against the squatter if you can show that your mark has acquired a reputation amongst Chinese consumers. Now, this is likely to be almost impossible if you've only manufactured there for export purposes, because Chinese customers simply won't be aware of your product. Where there's a squatter, it can also cause huge problems when it comes to due diligence exercises at investment or exit, as having your brand owned by a squatter could well put investors and purchasers off or decrease the value of your business. Some retailers and distributors in the Far East also won't sell your products unless you have a trademark registration certificate. And of course, you won't be able to get one of those if there's a squatter on the register already. In those circumstances, you could be forced to buy back your own brand, which is clearly not a very palatable thought and will also cost you many thousands of pounds. When it comes to challenging squatter trademark registrations and applications, this can be a difficult process. Bad faith isn't a concept that is recognised so much in China as it is in the rest of the world. Authorities are doing more to combat bad faith filings, for example, with oral hearings now being available, but requests for those hearings aren't always accepted and they can be evidentially burdensome and expensive. So you should do all you can now to avoid needing one later down the line. It's worth remembering that unregistered rights are not really recognised to the same extent that they are in many other countries. And even if they are, your use is unlikely to be sufficient, especially if you only manufacture for export purposes, as we've discussed. It's also a fairly common perception that authorities will often find in favour of the local applicant rather than the foreign opponent. So practically speaking, the trademark rights will go to whoever files first, which is all the more reason to make sure that you file early in all of the territories that are important to you. I thought it would also be useful to look at some common misconceptions about IP. The first being, I own the copyright. Well, think about it. Do you actually own the copyright? In the UK, the person that creates will be the owner, unless there's a contract that says otherwise. If the person that's created the IP, the copyright, is an employee of a business, that business will own it. If, on the other hand, the business has engaged the services of an external designer, that external party will own any copyright that's created, unless there's a document that makes clear that what has been created passes over to the commissioner of the work. The next common misconception is that I'm free to use my company name. It's worth remembering that the mere registration of a company name at Companies House doesn't actually confer any enforceable rights. That's simply an administrative exercise. Rights will only arise, certainly in the UK, when you start using a name as a brand, as a trademark, or better yet, once you've filed and registered it. The final point here is the assumption that simply doing nothing won't cause an issue. I'll be fine. Well, typically doing nothing is going to cause a problem. If you have, for example, a patent or design or something that might be subject to that protection and you simply publish that without filing, then that can be fatal to any future filing that you might want to make. You may have destroyed the novelty in it. Inventors will often dismiss their own ideas as not being clever enough because it seems so obvious to them. Well, of course, it's obvious to the person that creates it, but it's not obvious to anyone else. So don't dismiss what it is that you've created, because there may well be something in there that can be protected and that therefore can increase the value to your business as a business asset. So that brings us to the end of part 3 of our trademarks introduction. If you need any further information, then you can find our website at www.gje.com. If you have any questions you'd like to ask, then please email me at edward.carstairs@gje.com, or you can connect with me on LinkedIn. You can stay tuned for more sessions on both general and specific IP topics, and you can find other presentations we've given at our YouTube page with the link there at the bottom of the screen.